My name is Howard Black. I'm the Director of Communications for Colorado's 4th Judicial District Attorney's Office. Today's focus is on the court's unsealing of case 21CR3485. District Attorney Michael Allen, and that's Michaeallen, will be speaking to this case now that it has been legally unsealed. Christy Boots, Kristy Bootes, will be speaking as an independent expert on victim recantation. It's important to understand why victims choose not to cooperate or recant their statements. We are not going to be discussing in any area reference the homicide case. Following DA Allen and Ms. Boots, we will have a Q&A. With that, I'd like to introduce District Attorney Michael Allen.
Good afternoon, and thank you all for being here. I also want to recognize that one of our commissioners, Kami Bremer, is also here. Club Q resides within the district that she represents here in Colorado Springs, and she wants to express support to this office and to the victims of Club Q, and that's why she is here today. So again, thank you, Kami, for being here. The purpose of this press conference is pretty simple. It's to provide truth to the residents of the Pikes Peak region and to the nation regarding the prior investigation by El Paso County Sheriff's Office and the prosecution by this District Attorney's Office as related to 21CR3485. I'm not going to get into facts related to the Club Q shooting. It's imperative that we protect our ability to fully investigate and prosecute that case. Like I've said many times, we are not going to try that case in the media. It's also important to note that all persons charged with a crime are presumed innocent until proven guilty beyond a reasonable doubt, and that applies to the defendant in the Club Q shooting. It's also worth noting that the defendant in the Club Q shooting in that prior case, 21CR3485, was not convicted of any crimes in that case as related to the 2021 incident. This is simply an effort to correct the misinformation being spread by the media and certain politicians hoping to take advantage of the horrors associated with what happened at Club Q on November 19th. Everything I'm going to share was conducted and discussed in open court or was included in documents that are typically available to the public in that specific case. One of my unending missions as District Attorney is to continue to increase transparency into the role, functions, and results of the District Attorney's Office. At a time when the criminal justice system continues to be under attack from those hoping to reform it, transparency is required and demanded. Quite simply, the public deserves to know the truth. Our ability to be completely transparent has limits, and those limits are governed by ethics rules that govern our ability to practice law in the state of Colorado, and specifically as related to prosecutors, and then also state statutes govern what we can do with transparency. Some members of the media and certain politicians hoping to capitalize on the Club Q tragedy have reached conclusions that are wholly unsupported by any information available to them. That information has been unavailable to them because the very records they would have needed to make a conclusion have been sealed, making them inaccessible to the public. Those people should be ashamed of themselves. All they've accomplished is to cause harm to the victims of Club Q and to a community that is mourning the tragic loss of 5 lives and the shattering of the sense of safety we were all entitled to, including the people that are affected most directly by what happened at Club Q. So let's talk first about limits on transparency. I talked about ethics rules. Ethics Rule 3.6 governs what we do in the courtroom and how we conduct ourselves as lawyers admitted to practice law in the state of Colorado. It limits what a lawyer can say publicly about a case. These rules are precisely the reason why I'm always very careful about what we say about pending cases. Rule 3.6 has specific things listed that we say or cannot say. You can assess these by either looking at the screen or you can get them by going to the Colorado Bar Association website and looking up these rules. but it lists very specifically things we can and can't talk about. Rule 3.8 specifically talks about what prosecutors can do and what they can and can't say. These rules are exactly why I'm going to limit my comments today to what occurred in June of 2021 and as that case progressed through the court system. So let's talk about when we say no records exist. Colorado Revised Statutes 2472-703-2B. It's a very restrictive sealing statute that prevents DAs and other criminal justice agencies from making public comments about sealed cases. The result is confusion for the media and, more importantly, for the public. That confusion then leads to frustration and anger, both of which can be avoided if access to the records was available. CRS 2472-703-2B says specifically, upon an inquiry into a sealed record, a criminal justice agency shall reply that a public criminal record does not exist with respect to the defendant who is the subject of the sealed record. That's why when we get those questions, I say a public record does not exist. The language in the statute creates the ridiculous scenario where we know, the media knows, and the public knows that something happened, that something was filed with the court, and yet we have to make false statements to comply with the law if a case is sealed. We can literally be in the courtroom talking about a case, the judge dismisses the case, we go out into the hallway, judge dismisses the case and seals it, and then we go out into the hallway with the media person that was sitting in the courtroom. The media person asks us about that case, even though it just happened, we have to say no record exists. That very situation was at play in relation to the 21CR3485 case. A prior event happened, it was investigated by the El Paso County Sheriff's Office, and it was prosecuted by this office. That case was ultimately dismissed, and I'll talk in more detail about why that case was dismissed and the circumstances leading to that dismissal. Because of that sealing statute, the case was sealed at the request of the defendant. The legislature created this problem with the way the statute is written, and it must be changed. When a devastating crime is committed, and the citizens of this great state should have the ability to learn what happened in prior instances, including even in dismissed cases. The search for truth requires that. The absence of that ability led to where we are today, a false narrative being perpetuated throughout Colorado and the nation, causing damage and further hurting a mourning community. I'm calling on the legislature to amend the sealing statute, to allow an immediate unsealing if a serious crime is committed, or by prosecution request, requiring the court to unseal within 24 hours of a new crime being committed. I've talked with Tom Raines, the head of Colorado DA's Council, and with other DAs, including Michael Doherty in Boulder, Colorado, and John Kellner in Arapahoe County about this proposed change, and they all support it. And I encourage you all to reach out to those duly elected representatives, DAs, to get their comment. So let's talk about this specific case. Right, let me go back just a second. So on Monday, November 21st, 2022, so this is the first Monday after the Club Q shooting, my office filed a motion to unseal 21CR3485, that case. We filed it as quickly as we possibly could. I know that since our motion was filed, other people also filed motions, including some news agencies. I know that the Sheriff's Office also filed a motion to unseal that case. But because of my unending desire to increase transparency into the criminal justice system, we immediately filed that motion. Because again, the public deserves to know the truth. Today, the court ruled in our favor, giving me the ability to talk truthfully about that prior incident. So let's talk about the effect of filing felony charges. Mandatory protection orders automatically go into effect when we file a felony case, which achieve the same effect as a red flag order. It prevents someone from lawfully obtaining a firearm. We know from many years of experience that a piece of paper in the form of a mandatory protection order or even a civil protection order will not stop someone who is intent on hurting someone. The Glenn Galloway case from back in 2018 is a great example of that dynamic. It was a domestic violence case involving stalking and other domestic violence-related charges where a mandatory protection order was in place. That protection order did not stop him from killing his ex-girlfriend, Janice Nam, and an associate of his. ATF Form 4473 is the form that people have to fill out if they're going to lawfully obtain a firearm through a licensed gun dealer. Specifically, as it relates to questions 21D and 21E, which are highlighted on the screen. 21D asks if a person, generally speaking, is under felony charges, meaning have they been indicted or charged in any federal or state court with a felony charge. If a person answers yes to that question, they cannot lawfully obtain a firearm through the normal lawful process. 21E talks about if somebody has achieved or been convicted of a felony. If the answer is yes to that, they also cannot lawfully obtain a firearm through the normal lawful process, that background check. I encourage you all to look up Form 4473 and look at the particulars of that. The reason why it's important to point that out is that filing of federal charges is actually more resilient, long-lasting, and effective in preventing somebody who has been charged with a felony than is a red flag order. Red flag is also the Extreme Risk Protection Order. It was created in 2019 with CRS 13.14.5.101 through 13.14.5.114, and was signed into law on April 12, 2019. It's important to know that that is a mechanism of civil law as opposed to criminal law. At the time of drafting that statute, DAs were not included in the agencies intended to be included. How do we know that? The statute specifically directs law enforcement to work with city and county attorneys. If the law intended DAs to be involved, they would have included us in the language of that statute. The interpretation of the statute was shared by the Attorney General's office at the time in 2019 and other DAs in the state, including, again, Michael Doherty in Boulder, Colorado. A DA's focus is criminal law, not civil law. DAs to this day have still not been written into that statute. Because DAs are not included in Extreme Risk Protection Order legislation, I'm not going to go into too much depth in analysis of that law, though I will a little bit. From what I know, it seems unlikely that law enforcement would have been successful in achieving anything other than a temporary extreme risk protection order, which would have lasted for only 14 days from the date of that event, so starting on June 18th. But at the same time, he was arrested and charged with felony crimes stemming from that same date. So again, the felony charges lasted much longer than a temporary order would have. Again, a temporary extreme risk protection order prevents lawful transfer of firearms for a period of 14 days. Standard of proof is preponderance of the evidence, which is a low standard. And a court must find there's a significant risk of causing personal injury to self or others in the near future. It expires at the time of hearing for the extreme risk protection order, which is the longer extreme risk protection order that people talk about. The extreme risk protection order lasts for a period of 364 days, and I want you all to remember that number because I'll reference it later. It can be extended for an additional 364 days based on a further hearing from the court. The standard of proof is clear and convincing, and the court must find that respondent, the person that you're trying to take the guns from, poses a significant risk of causing personal injury to self or others. So let's talk about the timeline of events as it relates to 21CR3485. Law enforcement responded on June 18, 2021. Members of the El Paso County Sheriff's Office responded to a 911 call placed by Pamela Poland, the grandmother of Anderson Aldrich. The PC affidavit has been widely covered in the media and including statements made by Pamela Poland. Those statements, everyone would agree, are concerning statements. To get those statements into a courtroom in front of a jury to convict somebody, Pamela Poland would have to appear in court and take the witness stand and testify against her grandson. The U.S. and Colorado constitutions require witnesses to stand in court in front of a jury, subject to cross-examination, and testify. If we are unable to produce a witness, none of those statements would be admissible in a criminal courtroom. Deputies also had contact with his mother, Laura Vopel. They deployed the SWAT team to contain the residence. And Aldrich was eventually taken into custody and arrested for several crimes stemming from that incident. He was then held in custody pending formal charging process, and bond was set at $1 million. Charges were formally filed by the District Attorney's Office on June 29, 2021. It included 3 counts of first-degree kidnapping, with the victims being his 2 grandparents and his mother, and then 2 counts of menacing, which are F5s, with the victims being his grandparents. Search warrants were filed for and achieved, signed by a judge, and items were seized. Some of those things were 2 weapons. One was a pistol, noted in the evidence log as a ghost gun with Glock frame, no serial number, no model, no make, 9mm. The other was an MM15 5.56 rifle. It's important to note that both of those weapons are still in the custody of the sheriff's office today. In fact, after the Club Q shooting, I was able to look at those items because they remain in evidence and were never turned back over to the defendant. On August 5th, 2021, bond was modified. That date was originally supposed to be a preliminary hearing, but it was continued by the defense. The defendant and victims addressed the court regarding modification of the bond. The court also heard from his mother and his grandparents. His mother at that hearing described him as loving and passionate. His grandmother described him as a sweet young man and that he did not deserve to be in jail. The grandfather described him as unusually bright and someone who will take advantage of a second chance. It's important to remember those early statements that we talked about that were in the PC affidavit, obviously very concerning and something that law enforcement, meaning the sheriff's office and the DA's office, took very seriously. But later in time, we have different statements coming from those purported victims. The court modified the protection order, lifting the no contact with his mother, and modified the bond to $100,000 cash surety or property bond, and stated it was willing to lower further the bond if defendant was admitted to an inpatient program, and required the defendant to live with his mother and to participate in any therapy. Then the case continued to proceed. The defendant bonded out of CJC at the jail on August 7, 2021. Preliminary hearing was waived by the defense on August 26, 2021. Arraignment was continued by the defense on 2 times, October 21st and December 16th. On January 27th, the arraignment was held. The defendant formally entered a not guilty plea. For educational purposes, when an arraignment is held and somebody enters a not guilty plea, that starts the speedy trial clock, which means that we have 6 months by statute from that date to get that case to trial. I would note that this arraignment was done after several continuances by the defendant. The court then scheduled a pretrial conference and a jury trial. The pretrial conference was scheduled for May 19th and the jury trial May 31st of 2022. At the pretrial conference on May 19th, the defense announced ready for trial. The people, however, announced not ready for trial and filed a request to continue the trial setting. The prosecutor assigned to that case reported to the court attempts to achieve personal service on victims had not been successful. What that means is that the prosecutor was trying to get subpoenas served on the victims to order them to be in the courtroom, and that we had not been able to effectively serve those victims with the process of service. The court granted that continuance and rescheduled the jury trial. Pretrial conference was then set for June 23rd of 2022 and jury trial on July 5th of 2022. On June 23rd, 2022, at that pretrial conference, the people reported conditionally ready for trial, and the defense objected, reporting that both the prosecution and the defense are struggling to get service of subpoenas on the victims in the case. The people report attempting to work through the interstate subpoena process, because grandmother and grandfather had moved out of state. The interstate subpoena process is a lengthy process that requires us to work with authorities in a separate state to achieve service on witnesses that we are trying to get service on. And that process, though we had been working it, had not been effective, meaning that the out-of-state service process had not actually served the grandmother and the grandfather. At the jury trial date on July 5th, 2022, parties appeared again. The people reported that service on out-of-state witnesses was still not achieved by that date and requested another continuance to give us a chance to achieve service on those victims. It should be noted that I referenced earlier, the 6 months for speedy trial. Speedy trial was set to expire on roughly July 26, 2022, so just 3 weeks after that July 5th date. The defense objected to our request for a continuance and noted that speedy trial expires in roughly 3 weeks and moved for the case to be dismissed. The defense also noted that the people had been unable to achieve service of subpoenas on witnesses. And the defense stated, quote, "I believe that they probably made some very valiant efforts to get the victims served, but no likelihood these people are going to be showing up," end quote. And, quote, "These witnesses have basically been avoiding everyone." The court at that point denied the request for a continuance made by the prosecution and dismissed the case. I want to point out that there's nothing wrong with the court's decision in that reality. If witnesses cannot be produced at a trial and we are against speedy trial, it is very common for a court to dismiss a case. The court did not act inappropriately in that regard. On August 11, 2022, the case was sealed at request of the defense. And that is when all records associated with the case were sealed by the court. And that's what triggered the requirement of us to say no records exist. The order sealing the records applied to EPSO's records and DAO records and court records. Again, it's worth noting that the court acted properly in this situation and was in compliance with Colorado statute. Take no issue with the court's rulings. The status, again, of those weapons that were seized in this case is that they are still held as evidence. The defendant attempted to have those weapons released to him through contacting the sheriff's office, and that request was denied, meaning that we still have those weapons in our possession. I want to point out that the case was pending for 383 days under those felony charges. That is longer than an extreme risk protection order provides. The lawful transfer of firearms was absolutely prohibited for the entire time that felony case was pending. And the existence of 21CR3485 or even an extreme risk protection order would not have prevented the Club Q shooting. I would reference back to the ATF Form 4473 and the lawful process in which you would obtain a firearm. That gives an outline as to the case, the fact that it was prosecuted all the way up to almost the end of speedy trial, and that the court then dismissed properly that case because the witnesses were not cooperating with the prosecution. At this point, I want to turn this over to Christy Boots. She's a court-recognized expert and has served as a crime victim in this community for many years. She's going to talk about the dynamics associated with family members in situations like this. Before I do that, though, I want to reiterate, I've prosecuted many cases in my time as a prosecutor where grandparents or family members have reported against a child or a young person in the family because they have concerns about the safety. It is very common for people in that situation to have love for that person, to not want to testify against them, wanting to get them out of custody because they think they can handle it on their own. Whatever led to the victims not cooperating in that 21CR3485 case, I can't tell you. I can only tell you that they didn't cooperate, and it led to the dismissal of that case. But this office absolutely prosecuted it. We prosecuted it until we couldn't prosecute it any longer, and it would not have prevented the Club Q shooting. Now I'll turn it over to Christy.
Good afternoon. My name is Christy Boots, and I'm an independent expert witness, or expert not employed with the District Attorney's Office. I have been a crime victim advocate in this community and others for the last 14 years and have worked with over 6,000 victims. I'm here today to talk about why crime victims recant, because it is counterintuitive. I have provided expert witness testimony 70 times, and most have included victim recantation because it is such a common phenomenon when we're talking about family violence cases. When a victim of family violence recants, that means they're either fully retracting their statement, minimizing their statement, or refusing to repeat their statement. Now, there's many reasons why a crime victim may recant, but in my experience, the most common are love, fear, and guilt. They love the perpetrator, and they believe that they'll change. Often they'll want the relationship to continue, but that violent act to stop. They believe that their loved one they believe their promises to get help, and that there'll be no other further actions or further violence. Fear. Often victims of crime are fearful of the perpetrator. They're fearful of threats, fearful of future violence. It is likely that the perpetrator has carried out previous threats, and the victim believes that it will be the same in the future. And lastly, guilt. Guilt can be very powerful when we're talking about family violence cases. Excuse me. The victim will often feel responsible for the consequences that the perpetrator is facing. They'll often feel a responsibility to help them change or to change the perpetrator. Now, of course, these are not all the reasons why a victim of crime will recant, but in my experience, these are the most common. And again, victim recantation in family violence cases is incredibly common. Thank you.
So with that, we would open up for any questions.
You made very clear that you do not believe that had those charges moved forward, that this would have prevented the Club Q shooting. Can you elaborate on why that would be?
So actually what I specifically said is that that case would not have necessarily prevented Club Q. As to the reasons for that, I can't get into that because that will impact the Club Q investigation and prosecution. So you're just going to have to accept that statement that it would not have prevented Club Q. Obviously, the firearms that were seized in that 21CR case are still in our possession. You can take that and I think extrapolate out to what that means.
What would you want to say to people in the community who have questioned if it could have prevented the tragedy?
The only way that it would have prevented the tragedy is if the witnesses actually were present at trial, testified, and somebody was convicted. Again, he was not convicted in that case, and that person then was in custody for an extended period of time that would have got us past this event. Absent that, I don't see anything about that prior case that would have prevented this Club Q shooting, unfortunately.
So the 9mm pistol you mentioned was a ghost gun. That means that it is not legally registered to the defendant, correct? And also was the rifle legally registered to the defendant that was seized in the bomb threat case?
So as you know, that there's actually no lawful requirement to register a firearm with anybody, right? So really it's just the background check that's required to do a lawful purchase. Once somebody has that weapon in, those things would be investigated, but there's no registration requirement.
Okay.
Why were you unsuccessful in subpoenaing the grandparents, and how many efforts were made? Did you send people outside their house? What did that look like?
So it often means when we're trying to get personal service that we're sending people out to actually hand a piece of paper, a subpoena to those folks, multiple times, including interstate subpoena process, and those were not successful. Why they were not successful, you would have to ask people that were trying to be served why they were not successful.
So do you know if they ever got those papers and then chose not to show up?
If we had achieved service, then that would be a different thing. But each time, as I noted, we were reporting that service had not been achieved.
So was there any other way to legally get them out here? And if not, could you have moved forward without the grandparents as witnesses?
So in every case where you have trouble getting the actual witnesses, the victims, the listed victims into court, you have to make judgment calls. In this case, obviously, the prosecutor was not able to go forward without those victims because those statements that they made, those concerning statements that have been widely covered, obviously very concerning, but those are being made by the grandmother and the mother. Without those people actually taking the stand and testifying to those statements, there's no way that you would convict them on the kidnapping and the menacing charges. You know, it's really, why didn't they come? That's an answer that they would have to give.
So
I'd
you,
like to get back to those guns. Was that rifle a ghost gun, or was it,
Not to my knowledge.
do you know how it was purchased, who purchased it, who owned it?
I don't know.
On the subpoenas, grandparents were in Florida, but mom still lived here. What efforts were made to subpoena her?
The same thing, trying to go person to person and hand her a subpoena. But if somebody is, for some reason, not able to be found, you can't serve them with a subpoena.
We spoke with Leslie Bowman, who's the landlord of the Lordson Ranch home, and she was concerned, was she ever interviewed or asked to come into court?
I'm not sure whether she was actually served with a subpoena, but again, she's not a direct witness to what happened on that day. So she would not necessarily be a victim that is going, or a witness that's going to prove the charges. We have to get the victims in to prove those charges.
We have Ring doorbell camera that
Yeah.
shows some of that. Was that brought forward in the case?
That's part of the case, absolutely.
Were
So
you
there's
aware of the
still-
Facebook video as well?
So one at a time, go ahead.
So with the Ring camera, with the Facebook, with concerned landlords, there's still nothing you guys could have done. You're saying you guys did everything you could to make sure this person who said he's aspiring to be a mass shooter, or they are aspiring to be a mass shooter, is free.
Yeah, so, I mean, if you think about who said those statements, do we know who said the statements? I mean, you all have seen the affidavit, right? It was grandmother, well, some people have. I know that some news stations have been reporting and waving papers around like they've got the affidavit in their hands. The affidavit specifically says that grandmother made those statements. So to get those statements in front of a jury, grandmother has to get on the stand, swear an oath to testify truthfully, and then testify and be subject to cross-examination. If we can't make her get to the courtroom, those statements are never coming in a criminal trial.
And so the judge has no choice either, you think?
The judge did everything that she should have done. I mean, she gave us one continuance because of the difficulties getting victims served. We were at the end of speedy trial, essentially. It probably appeared to the judge that there was no likelihood that these people were going to submit to service. And even the defense attorney said that these victims were avoiding everyone in the case, including the defense.
did the judge have to dismiss the case though?
So speedy trial, when it runs, it runs. That means the case is over.
So could she have granted a continuance and therefore the extreme risk protection order would still be in place?
There was no extreme risk protection order in place. It was
Well, the
the
felony charge that he could have.
felony charges.
So
The
would that
felony
still be
charges
in
were
place?
pending for 383 days at the time that they were dismissed.
But if the judge had granted a continuance, would that still be in place?
It would have been for a short amount of time, potentially, but when there's no likelihood that the witnesses are actually going to show up to testify, there's really no fault of the courts even in that
So
point.
at what point do you decide, for lack of better terms, to give up to subpoena witnesses when you have someone saying they
First of
want
all,
to be
I'm
the
going
next
to
mass killer?
contest what you said. Nobody gave up on this case. We were fighting this case to the very end. We asked for a continuance the day that it was dismissed. Let's move on to some more questions.
Mandatory protection orders, under my understanding, also require you to give up any other firearms.
Yep.
Did anything happen in terms of, were you able to get any other firearms from the defendant during the time those
No other
charges-
firearms were obtained in that investigation, signifying, I guess, that he probably didn't have any others at that time.
He stated that he reached out to the sheriff's office to get his guns back. When did he do that?
You would have to ask the sheriff's office.
I
Mr. Allen,
understand
you
you
said
knew-
that your office can do a red flag order or request one. I'm just wondering though, say another agency did request a red flag order after the case is dropped. Wouldn't that have stopped the suspect from legally buying another gun?
So I'm going to answer that in a general question because I think you're asking it in a generalized way. Theoretically, yes. As you apply it to this particular case, where you've got statements that are concerning at the front end, and then after that you've got witnesses that are not cooperating, and they're also saying really nice things about the person, saying that he's loving and compassionate and intelligent and all of those things. The likelihood that a permanent extreme risk protection order, so the longer version of the 364, goes down significantly in my mind, because those people would also have to testify in that case as well.
That's a higher standard than the temporary.
Yes, it is.
Do you support the governor's call to allow, or to add district attorneys specifically to the list of people that can request?
So I'm certainly up to engaging in discussion and potentially modifying that legislation to make it appropriately fit certain situations. But again, I want to point out that when we file felony charges, it's just as strong as, if not stronger than, an extreme risk protection order because of those mandatory protection orders that are automatically put in place at the filing of a felony charge. If a felony conviction is achieved, that lasts much longer than an extreme risk protection order. So the idea that, and I referenced this earlier, the idea that a piece of paper, a protection order that is in place will prevent somebody that is bound and determined to do something bad against somebody else, oftentimes doesn't stop somebody from doing that.
Quite a few of the ERPO cases that have been granted by judges included mental health treatment or other counseling and that sort of thing.
Absolutely. I mean, there are certain...
That's something that would happen in a case like this where your criminal case eventually was dismissed, correct?
It could. So I'll give you actually an example that we had locally before extreme risk protection order was in place. It was on a Halloween day before extreme risk protection order where a gunman actually was walking down the street and shot several people, killing them, and then was killed at the end of that encounter with police. What would have worked well in that case is that the parents were on the East Coast, called police to say that there were big concerns about this person potentially carrying out violence in the community. They were on their way out here. If an extreme risk protection order had been in place in that scenario, kind of what you're talking about, mental health concerns and a danger, an exhibited danger to self or others, it could have prevented that shooting. So there are certain scenarios where it can be effective, and that's a really good example.
Do you think the sheriff's office could have helped more, and if so, how?
The sheriff's office, I'm not sure exactly what you mean by helped more, other than I know that they investigated this case, gave it to us. They knew that there were felony charges in place, so I'm not sure what more they necessarily could have done. I think you can ask them that, though.
Can you explain more of the efforts with that interstate subpoena process?
Yeah, so I can't tell you specifics step by step what happened. We have to go through very formal steps to notify authorities in another state of that interstate subpoena request. Then they have to then actually go to court in that place with the person to talk about when they can be ordered to appear and all of those things. Those things happen on cases very routinely. We do interstate subpoenas all the time on cases involving out-of-state witnesses. Can I tell you specifically what went on? No, I can't at this point, but I can only tell you that through that process, the subpoenas were not served on the grandmother and the grandfather.
Is it fair to say that you believe that the family was avoiding your subpoenas, consciously making efforts to do so?
I would say that that's a reasonable conclusion that somebody can draw. I'm not going to speculate.
On what grounds did law enforcement hold on to the suspect's gun after the criminal case was closed and there wasn't extreme risk protection order?
You would have to ask the sheriff's office.
What exactly are the requirements for the service of the subpoena? Do you have to put it directly in somebody's hands, or can it just go in the mailbox, or how does that work?
So there's two different ways that we serve subpoenas. Most often we do it by mail, where we send somebody a subpoena, and what they have to do to acknowledge that they've received subpoena service and are going to comply with that subpoena is they mail us a return subpoena back to us, so that we have record that they received it and that they are going to comply with the conditions of that subpoena. If we are not successful through getting subpoena service through that, then we will often go to personal service, and that requires us to personally hand, so a process server personally hand a subpoena directly to that witness. That is a perfected service of subpoena.
I have to imagine there was frustration in your office for not being able to talk about this case for so long. What do you want people in the community to know about this case?
And I assume you're asking about 21CR case. Yeah. I think what I want them to know is to correct the record. This office prosecuted that case until we couldn't prosecute it any longer. I want the community to know that as soon as the Club Q shooting happened, we immediately began working to unseal that case so that the public could have the truth. When we have a void of information and then people, for one reason or another, create a false narrative about that scenario, you have to question, first of all, why are they creating a false scenario? And what's the impact on the community? And what's the impact on the victims in this case, people that are hurting? And that's why we filed our motion the first business day that we could to unseal this. Obviously, the court system takes time. And so I would just encourage people that when you see people jumping to a conclusion without having all of the facts, maybe they should question the motive behind jumping to that conclusion.
Is there any way that it could have happened faster, this motion, given the public interest? You're saying it caused problems.
Yeah,
within
so
several weeks.
So the question is, could this have happened faster, the unsealing? I think that's a fantastic question. That's why I'm calling for an amendment to that statute. That would, if a certain level of crime, I think it should be an F3 or higher. If it's committed, it automatically unseals prior cases, even dismissed cases. Or if the district attorney requests the case to be unsealed, that the court has to rule within 24 hours of that request. I think that would fix what happened here.
I just want to make sure I have this right, that without the witnesses, the DA's office didn't feel confident enough to move forward to prosecute, even though guns were found in bomb-making materials and you knew those statements that were made.
Possessing guns by themselves is not illegal. You have to have witnesses that are listed victims to come into the courtroom and testify as to why they are a victim, what happened to them, what was said to them, what they saw. Without those witnesses getting on the stand, there's no way to get a conviction on those charges. Whether we felt confident or not, I would disagree with your characterization. Any other questions?
We just heard about the tendency for family members to defend their family member or hope that they could change. Is there an option for a character witness to be brought forth in a situation like this when we know that the family might not characterize that person accurately or truthfully?
So actually, criminal law is very careful about character witnesses coming in to testify. There has to be certain situations present because you don't want to convict somebody just based on character alone. You have to convict somebody on their actual actions. Did they actually commit a crime? And so if we start bringing in character evidence, that's oftentimes improper unless there's something that causes that character evidence to come into play. And really, you still need the victims to come in and testify. You can never get away from the hearsay rules. That's really what this comes down to. You can't get away from requiring that victim to take the stand, testify to tell the truth, and then be subject to cross-examination.
What about the...
Well, go here and then I'll come back to you.
What did the grandma say specifically that was so concerning to your office?
So talking about that he wanted to be the next mass shooter, that he was potentially going to blow things up, all those things. Everything that she said and has been widely reported on are concerning statements and are something that we take very seriously.
You talked about the false narrative that's been harming the community, that's hurting. I don't want to, it sounds like you're saying that false narrative is that something could have been done in this case to prevent the Club Q shooting. Is that what the false narrative is?
Yeah, I mean, if there's a false narrative that's created for whatever that reason is, and it causes victims in this case to doubt our ability to prosecute this case, that causes them pain, it causes damage to the criminal justice system, and it's simply not true. And so I would just encourage people to seek the truth. And that's what this is all about, is getting the truth out.
Well, what is false? Is it that there's something that could, you're saying nothing could have been done with this case to stop the Club Q shooting? Like
I said, short of that person being convicted and put into custody status, that, in my mind, is really the only thing that could have stopped something like this. The false narrative has been widely reported, including that we didn't prosecute the case, that we dismissed the case, people saying that we didn't pursue red flag. Red flag doesn't apply to the DA's office as it's currently written. So that's the false narrative that I'm talking about, that somehow we were not doing the things that we were supposed to be doing, when in fact we did everything we could have done on that case.
So there's nothing you would change about how you prosecuted the case?
I'm going to go to the next question.
The sheriff's office couldn't pursue an extreme risk protection order without the cooperation of the family witnesses. Should they have done that? And I'll just say in that case, they could have extended it for, he could still be under it, they could have done it for 2 years.
Right.
So should that have happened?
I'm not going to say whether that should or should not have happened. That's a question I think that's better directed to them. But I would point out that that temporary extreme risk protection only lasts for 14 days. And then to achieve the actual extreme risk protection, I think that first of all, the standard of proof is much higher. I don't think, based on the conduct of the witnesses in this case, that they would have been successful on that. But again, whether they should have or not, I think is a question for somebody else.
Was there any audio or video recording of the statements made by the grandmother and the grandfather?
That's a good, I don't know that off the top of my head. But even if there was a recording, the grandmother still has to take the stand. So what will often happen is if a witness is interviewed in a case and it's audio and video recorded, we can't just put the detective on to say, hey, I interviewed this person and this is what they said, because every statement that that person said on that recording would be hearsay statements. So you still have to get the actual person on the stand to testify to those statements. If they recant on the stand, there are ways that you can then get those statements in after the fact, but the first step is getting them on the stand and getting them to say something.
You mentioned there were discussions of maybe therapy or mental health help for Aldrich after to lower the bond amount. Was any of that ever enacted for him or they? And were there any follow-ups?
Yeah, so that's a question I think that actually potentially could impact our current case, so I'm going to stay away from that one, okay?
Isn't it illegal to have a ghost gun? Could you have pursued charges for that?
So that is a problem that I think that we have to figure out a way to solve legislatively. I'm more than happy to engage in legislative efforts on that effort. It's a hard area to regulate. There are plenty of websites that you can go and buy parts of guns that don't have serial numbers on them. There's got to be a way to somehow regulate that better. But you also have to talk about and be cognizant of people's constitutional rights. If we're going to talk about taking away somebody's constitutional right to possess firearms, what are the safeguards that are going to be put in place to make sure that we're not infringing on people's constitutionally protected rights? It's a discussion that has to happen legislatively to find a solution there. And I'll certainly engage in that. Exactly, yeah. And there have been discussions about that. As far as details, I think it's way too soon to talk about details.
Correct me if I'm wrong, it's not illegal to make a ghost gun for your own use. It is illegal to make one and sell it to somebody else.
That's exactly right.
Is there any evidence that he bought that ghost gun?
That's something I think that we need to know more about. The thing that's hard to do, though, too, is there's not necessarily tracking on those types of things. So even if there was a private transfer, unless we have somebody coming out and saying that there was a private transfer, you probably couldn't prove that. So that is actually one area that I think we could have legislation on, is if you're in possession of a ghost gun, making that some sort of a crime. That would be potentially an effective fix.
And there's no recourse with back then with the mother or the grandparents for ducting subpoenas, correct?
It's not a crime to duck service of subpoenas.
Let's see, two more questions. Who hasn't asked any questions at this point?
So we'll go there.
You mentioned that it's common for the judge to dismiss cases like this, but when we're talking about 5 felonies, how common is that?
If you can't, it doesn't matter how many felonies you have. If you have 100 felonies and you can't get the victims to come and testify, it would be very common for a judge to dismiss in that case, because we have a constitutional requirement set out in statute that says we have 6 months from the time of arraignment to get to the trial. If we can't get that case to trial because witnesses are not cooperating or not appearing in court, it's not uncommon for a case to get dismissed, and it doesn't matter how many charges there are.
How often would you say this happens with your office in terms of?
Not very often. We file a lot of cases. We file more cases than any other DA's office. There's a percentage. I don't have that stat in front of me. Most cases resolve in plea agreements. It's between 95 and 97% of our cases result in plea agreement. And then we have a number that go to trial. I think our trial stats so far for this year, including misdemeanor and felonies, is 350 plus, something like that. So we take lots of cases to trial. There's a percentage of them that get dismissed under this scenario, but it's a small percent.
You have mentioned that the suspect, while the felony case was pending, could not legally buy weapons. Do you have any evidence that they illegally bought weapons during the pending felony case?
So I'm not going to get into that. I think that's really getting into the new shooting. Good? Okay. Thank you, everybody.
Okay, thank you.